I disagree with his literal interpretation. Larry Brock and Glen Motz highly disagree with this Liberal MP regarding the Emergency Act. Here's the clip.
It's Senator Harder. So thank you, Senator Harder. You have the floor. Well, overall, I don't agree. But my Liberal colleagues may not agree to the amendment.
As Senator Harder was referencing, I think it's really important that the committee draws reference to and that the record reflects what Section 62.1 and what Section 63.1 actually say in the statute. So 62.1, which relates to us, the Parliamentary Review Committee, says, and I quote, "The exercise of powers and the performance of duties and functions pursuant to a declaration of emergency shall be reviewed by a committee of both houses of Parliament designated or established for that purpose." So that is this committee with representatives of the Senate and members of Parliament. And what we are meant to be looking at is, quote, "the exercise of powers and performance of duties and functions pursuant to a declaration of emergency." In contrast, and this has come up in respect of the debate we were having just about 10 minutes ago, there's also contemplated an inquiry, which has to occur. And that inquiry is entrenched in Section 63.1 of the same statute, and I'll read it. It says, quote, "The Governing Council shall, within 60 days after the expiration or revocation of a declaration of emergency, cause an inquiry to be held," and here's the important part, "into the circumstances that led to the declaration being issued and the measures taken for dealing with the emergency." And the key point here, Mr. Chair, is that the inquiry has a retrospective and a prospective element, whereas the review committee does not have a retrospective element whatsoever vis-a-vis what happened prior to the invocation of the declaration. It speaks simply to the exercises of powers and performances of duties under that declaration. So I think Senator Harder's point is very well taken, because the first three bullets of what Mr. Motz is proposing are retrospective in their nature and clearly outside of the scope of Section 62.1. It's open for debate whether the remaining three, and these being the choice and necessity of regulations, the constitutionality of those regulations, and the use made of those regulations, fits squarely within 62.1. So that's my first general point, Mr. Chair. The second point I would have is that it may be premature to be looking at this without the advice and input of people experienced in interpreting these types of provisions, so that people aren't taking my word for it or the word of any of my colleagues. And by those people, I mean perhaps hearing from the law clerk of the House of Commons or the law clerk of the Senate to help us with scoping the study before we take a preliminary decision on a motion without having the benefit of their interpretation of 62.1 and 63.1. So I will leave it at that. I would also say, actually, as a further submission, when you look at the context of the motion, so now I'm referring to the motion that was passed in the House of Commons, on which 6 of us, I guess, voted. It says in subsection A, the very first paragraph of that motion, it says, pursuant to subsection 62.1 of the Emergencies Act, that's the section I just read, a special joint committee of the Senate and the House of Commons be appointed, quote, "to review the exercise of powers and the performance of duties and functions pursuant to the declaration of emergency." Again, it is not retrospective in nature. It is contemporary, what happened when the invocation was declared. So I'll leave it at that. Thank you, Mr. Chair.
Merci, Monsieur Virani.
Thank you, Mr. Virani. Now, Ms. Bandayan, and then Mr. Brock, Mr. Motz, and the Senator. Yes, I'd rather speak after my colleagues. So, Mr. Brock.
Mr. Chair, this is not an exercise of judicial interpretation of a statute. That is not our responsibility. And while I have the utmost respect for my colleague, Mr. Virani, I respectfully disagree with his literal interpretation of the language of this particular statute. An argument could be made. I do not dismiss his argument, but our mandate is to provide clarity to Canadians, not necessarily just taking a look at a snapshot in time from the date of invocation and reviewing all the circumstances prospectively forward. In my opinion, sir, with all due respect, it would be a derelict of our responsibility without taking a look at all of the circumstances that created the emergency in the first place. In our view, no one can reasonably be expected to review the declaration without looking at the reasons for the declaration. If the emergency proclamation was unlawful, it follows that the exercise of powers would be equally unlawful. Thank you.
Merci, Monsieur Brock. Monsieur
Thank you, Mr. Brock. Mr. Motz.
Thank you, Chair, and I won't add much more than the eloquency of my friend, but I would agree. As I read this once I realized that was going to be on the committee. To me, the exercise of powers is exactly, in order to understand how those powers were exercised, you have to understand the circumstances which led them to believe they needed to be exercised in the first place. So Canadians, and you have to look at this through the eye of a Canadian who is concerned and watching what we do on this, no one can reasonably be expected to review this declaration and whether it was appropriate or not without looking at the reason behind the invocation in the first place. And so, if the emergency's proclamation was unlawful, it follows then that the invocation itself or the exercise of powers would be equally unlawful if that's what the conclusion is. So, as Mr. Brock said, it would certainly be reasonable for us to have a full view of those who made the decision in the first place to invocate this Emergencies Act. How can we possibly say whether it was appropriate or not without having the same set of circumstances that they looked at to make their decision that we also look at to make our decision? And so I would respectfully have to disagree with Mr. Virani and suggest that there might be other bullet points, if we will, about this motion that we can add to this to give us a fulsome. But I guess one way to look at it is, if you're looking at it from those of us who've been a law enforcement perspective, when you look at an arrest, the lawfulness of that arrest is looked at in its totality, the reasonableness of it, and if you're doing a search, was it a warrantless search? Was that warrantless search reasonable? You have to look at all the factors that led to that conclusion, and frankly, for me, I can't make a fully informed decision on whether this was appropriate or not without seeing all the facts that everybody else at that time used to make that decision.
Merci, Monsieur Motz. Monsieur Carignan.
Thank you, Mr. Motz. Senator Carignan. Well,